So Ram asked me that, so young man, what do you want? So I said, I've always had this dream of becoming a lawyer, but I'm told that there's a glut of lawyers and lawyers are on the streets begging for briefs. So Ram said something to me which was really, very prescient. He said, do you want to be a good lawyer or a bad lawyer? So I said, well, if I want to be a lawyer, naturally I would want to be a good lawyer. And he said, if you want to be a good lawyer, then there is an acute shortage of good lawyers. The police authorities do is they make a narrative. They are not now investigating. They're picking up people on suspicion, but based on a narrative. And the charge sheets are filed of 5,000, 6,000, 7,000 pages, 12,000 pages charge sheets, which are just one long narrative. Let me say this loud and clear, that I don't believe that any judge of the Supreme Court of India does not know, hand on heart, what is the reality of these incarcerations in Bhima Koregaon, in the Delhi riots cases. I do not believe that any judge believes in their heart that there is even an iota of truth in the charges. Either the state ensures a speedy trial or the person must be granted bail. That's all there is to it. There's nothing, there's no, it's not rocket science. It's not something which requires Einstein to come down from the heavens and explain this law to us. You know, we all must understand what is Article 21. It's one of the most cherished fundamental rights. It's not given to us by the Constitution. It's a basic right. It's an inherent human right. It was there from 5,000 years. It was there from 5 million years ago. Justice Sanjeev Khanna, when he was in court number 2, he said it in open court. He said, Mr. Solicitor General, Mr. Raju was arguing a matter. He said, 2 questions in cross-examination and your entire liquor scandal case will go. Right? What happened? The trial court has given a 589-page judgment saying that there is not even an iota of a case for framing of charges. Justice Sanjeev Khanna said this 2 years ago. 2 questions in cross-examination, Mr. Solicitor General, your case will go. And they can't frame charges. Big liquor scandal. People were Chief Minister, Deputy Chief Minister, Home Minister of Delhi government, Ms. K. Kavita from Telangana, 23 accused. All top politicians, businessmen, etc., all discharged. You know, when we talk about bail, we must know this. We know these are all hollow cases. These are all narrative-based cases. There's nothing in them. They will all crash when they are tested. What has happened now is that without any emergency being there, media has become the cheerleaders for the government. Who could ever imagine that there would be journalists riding on JCB bulldozers, riding with the driver and with a mic and a camera, bulldozing somebody's home and cheering it.
Hello everyone, welcome to LiveLaw. I'm your host Nazarat Fatima, and this is the 6th episode of our series where we talk to people from the legal fraternity who are also interested in different forms of art, or there's a specific element to their life which is very interesting, and that is something we love to talk about. We have with us today Mr. Chander Uday Singh, Senior Advocate, Supreme Court of India, and we also have with us Mr. P.V. Dinesh, again Senior Advocate, Supreme Court of India, who would join me in this conversation. So before we start talking about the other things, I'd like to talk about why there was a switch from journalism to law.
It was really something that I loved doing. I was always writing, even when I was in college, and after college I was farming for 3 years. While I went through law school, it was just natural for me to take up writing. And initially I worked as a freelance writer for some magazines in Mumbai. And then I was offered a full-time job with India Today, which was then a fortnightly news magazine. And I finally joined them and stayed on with them for 4 years, from 1980 to 1984, during which time I got myself a law degree and finally gave them 1 year's notice and then switched careers.
So was the legal profession like a dream for you?
It was that I always had this fantasy about becoming a lawyer, but I always believed that it was something which was absolutely unattainable. I'm not from a legal background, so I always thought that it was possible for a complete newcomer to become a lawyer. At least I didn't think it could happen. The only lawyers that I actually saw in Mumbai when I was in college were the unfortunate crowds outside the Killa court who would come running out every time a taxi stopped over there. They would come running out and beg for briefs, and so I thought that was what lawyers did.
One interesting thing you told me once, that your mother and yourself went to Mr. Jethmalani and sought some advice.
Not my mother and I, but she set up an appointment for me with Ram Jethmalani. I was farming in those days, and I used to run a dairy farm about 60 kilometers from Delhi. I used to supply my milk in Delhi to the Maurya and Taj and Nirulas. So I came here to Delhi every day, and my mother was desperate for me to get out of farming. So she was always trying to find some way of getting me out of there. And so I felt that if there's one thing that I might really want to do as being more important to me than farming, it was law. So she set up an appointment for me with Ram Jethmalani, and I went and met him on a Sunday at his house in Delhi on Prithviraj Road or wherever. So Ram asked me that, so young man, what do you want? So I said, I've always had this dream of becoming a lawyer, but I'm told that there's a glut of lawyers and lawyers are on the streets begging for briefs. So Ram said something to me which was really, very prescient. He said, do you want to be a good lawyer or a bad lawyer? So I said, well, if I want to be a lawyer, naturally I would want to be a good lawyer. And he said, if you want to be a good lawyer, then there is an acute shortage of good lawyers. And it is the crowds who will be chasing and desperately trying to get an appointment with a good lawyer. There's a glut of bad lawyers in this country. He says there's no doubt about that. But if you don't want to be a bad lawyer, you won't be part of that glut.
I think that statement is quite relevant. There is absolute dearth of good lawyers, and we have got a lot of lawyers.
Yeah, well, I think now it's more democratized perhaps than then because of the law firms and all the national law universities and all. I think there far more, there's a greater supply of good lawyers coming into the system. Some of them may not even want to practice. They may just want the appellation of being a lawyer. But many of them who want to practice also, unfortunately, don't have the wherewithal or the means or the exposure to come up in life.
But what I feel is the so-called good lawyers, most of them are not having commitment or conviction like you. That I've seen. I've noticed.
Well, I'm not going to blow my own trumpet, but we do have a dearth in India of institutionalized legal aid. So apart from what some lawyers do of their own accord, I do end up spending a lot of my time on work which I believe in, and a lot of it is pro bono work, etc. But that is unstructured. The structured legal assistance can only come if you have a completely widespread, deeply rooted legal aid system, and you have also perhaps some way of encouraging the best lawyers in the country to participate in that system. So it can be done, but once it's structured, then even the best lawyers come into it. I'm given to understand that in the United States and Britain, even the top law firms have to devote a certain amount of their time. Their partners, their senior partners have to devote a certain amount of their time on pro bono work, etc. And it is reflected in there's a professional commitment which they have to do and they have to keep to and all that.
So the pro bono, I can understand. Pro bono or commitment doing legal aid work. But whenever there is constitutional issue, and when you express your opinion, then the people start treating you as somebody who is against the national spirit or anti-national. You don't have such feelings. You express your opinion very boldly.
I think there are phases in every nation's development and life of a nation where these things happen, where there are phases where people who are the so-called progressives or the liberals are seen as being very vital to the lifeblood of the nation, and there are other phases where they are suddenly reviled as anti-national and stuff like that. I guess with lawyers, it's I take it as just a phase, and I'm sure this phase is also going to pass. Like, all things must pass, and this too shall pass. I think it would be good if even the most right-wing and the most left-wing lawyers all are forced to devote a certain amount of their time and effort on
I think
working for the
Yes.
underprivileged, working for people who need their help, working for, even advisory service to poor people and all that. It's so needed in our country.
As Justice Krishna Iyer put it, preamble of the Constitution should be the manifesto of the country. That should be the politics, I believe. Politics of a lawyer.
That would be great. Yeah.
So, because you have a standing of so many years, and of course, we talked about the good and bad lawyers. How do you define a good lawyer?
Well, I don't want to sit in judgment over my brethren at the bar, but I would say that really the crux of a good lawyer is somebody who actually works on the case of their client, who works genuinely from the heart and works hard on it. Whatever the client might be a top fat cat industrialist, the client might be a poor person who's in jail, the client might be a person who's on death row, the client might be a victim of molestation or assault or rape or whatever. But if a lawyer was to take, let's say we practice in an appellate forum, which is essentially the Supreme Court is mainly an appellate forum. We get cases which have already been handled by other lawyers, by the whole legal system before they come to us. There are judges who have applied their minds to it. There might be a single judge of a high court, a division bench of a high court. There might be a trial court. So many minds have been applied to that case, and then it comes to us. So in our appellate practice, I would say, what is a good lawyer? A good lawyer is someone who would take that case that is brought by an advocate on record or a law firm and add something more to it. And not just take the case which has been developed and just spout it out to the court. I think it's very important to at least put in enough to put in enough effort that you can say that with a clear conscience, you can say that I have brought something to the table. I have brought something of my own to the table on this case. I have advanced it beyond what was given to me. I look for some solutions which may not have been seen. Sometimes you find them, sometimes you don't. It's not that you'll always find them, but I think that effort is what what distinguishes a good lawyer from an ordinary lawyer. I wouldn't say bad lawyer, but from an ordinary lawyer.
So this answer actually reminded me of a clip that was quite viral on social media, that there was this lawyer who was asked the same question about being a good lawyer. And he said that if there's a criminal who's actually committed the crime, he would still, if there's somebody who's committed a murder or somebody who's committed a rape or something like that, he would still fight his case because that's what, as a lawyer, a person is supposed to do. So my question as a young lawyer to you is morality subjective in case of lawyers?
No, I see. The best way, the easiest way of seeing it is from an extreme case. So take somebody who's committed a very, very heinous crime and is on death row. That means the person has been convicted and has been sentenced to death. Right now, quite often the person has done it. Sometimes maybe the person has not done it. So that is on the conviction part. But even if a person is convicted, and even if the court upholds the conviction, there are still a shade, or let me not say conviction, even if a person has done the act which has led to the death of somebody else, there are so many shades of outcomes which could be there. First of all, it could have been done in the right of private defense. It could have been a self-defense thing. So you've killed somebody, but you kill the person while trying to defend yourself. So there could be a complete acquittal. Though everybody knows that I've killed, even I admit that I've killed the person, but I could still be acquitted. There could be a situation where it is proved that the person was incapable at that time, incapable of coherent thought, like due to being absolutely plastered drunk, or being, having lost his senses due to some other reason, etc., etc. Or, again, which could lead to total acquittal also. Or it could be that there are some other mitigating circumstances. So how does a lawyer get into the moral sphere and moral field and decide that I will play God and I will decide what this person deserves? Right? If I was to say at the outset that no, I'm not going to fight this person's case because I think it's very immoral to fight a person's case, then I'm playing God or I'm playing a judge. That I've already done the judging, but I'm not a judge, I'm a lawyer. And as a lawyer, my role is to get that person the best possible deal given the circumstances, without lying to the court, without manipulating documents, without doing forgery, but within the framework of the facts as they stand, within the framework of the prosecution meeting its burden of proof, etc., etc., I'm entitled to argue to the hilt and try to get my client off to the hilt. Even if I know that the client has done it, but if the prosecution miserably fails in discharging its burden of proof, I'm legitimately entitled to try and get my client off.
Because we're talking to a person who's been a journalist and is now a lawyer, so we'll be jumping between conversations. So about media, what do you think these days, the media in the present times, do you think it needs to be regulated?
So first of all, that word regulated is something which is anathema to me. I don't believe that media should be regulated at all, except where it crosses limits and then meets with barriers, like if media indulges in hate speech, if media indulges in libel or defamation or whatever, then it must meet the consequences of that. But that is not regulation, because when we talk about regulation, it becomes a form of censorship, and we are facing that. But if you're talking about media's role in today's India, which is different from regulation, which is media discharging the role that we as citizens would want it to discharge, or which I believe we are entitled to demand that it discharges, then I think the media is miserably failing to do so. At least all mainstream media, by and large, the biggest newspapers, virtually all television channels, virtually all big-time establishment media is playing the role of not even lapdogs of the government, but they virtually have become cheerleaders of the government, which is a very, very sad situation. During the emergency of 1975 to 1977, media was completely muzzled by law and by the Constitution being suspended, by 1918 being suspended. Media was completely muzzled, and journalists would be jailed the moment, or any newspaper proprietor would be put behind bars if they published anything without showing it to the censors. There was pre-censorship in those days. You had to give your galleys and show it to the censors who were sitting in every newspaper office, etc. But during that time, the media maintained a silence which I believe was a very sullen silence. There was a silence which was sullen. They were silent, but they hated it. And that showed. What has happened now is that without any emergency being there, media has become the cheerleaders for the government. So far from being cowed down into silence, they've gone to the other extreme where they become like spokespersons for the government. They've become like the cover-up agents of the government. They've become like the promoters of every lie which the state puts forth, etc. So it's like, who could ever imagine that there would be journalists riding on JCB bulldozers, riding with the driver and with a mic and a camera, bulldozing somebody's home and cheering it. I mean, this is appalling. This is something which I could never imagine that media would fall to such depths. Gire hue se bhi gire hue. It is like utterly shameful. And that is the state of our media today, of our mainstream media,
So
which
basically
is...
the standards have fallen.
Do you expect some hope in social media? Because I can see a lot of social media handles handling the issues which mainstream, the so-called mainstream, I don't know whether it is right to call this mainstream media as mainstream media. They're no longer a mainstream media now. But the social media is actively revealing things or discussing things which really matters.
So I think from whatever I gather, the gap which is left, the space which is left for, which is vacated by the large media, when I say mainstream media, I mean the large establishment media. The space which they vacated, which is the space of information, of informing people of events and developments and things which are happening around them, things which are important to the nation, etc., etc. That space which is vacated has to be filled by somebody. In 1975, in the emergency, it was filled by little pamphlets, little leaflets, which would be surreptitiously printed and circulated, and by word of mouth. Right? Today, it's been serendipitous and it's been very, very, it has been a saving grace in a lot of countries which are faced with autocratic or semi-autocratic, leadership, that these avenues have opened up. The avenues may have good and bad, again, like everywhere else, but the fact that they are available, like today you have online newspapers, you have a large number of them. Not just in English language. In English language, you have everything from NewsClick to The Wire to the Indian Cable to the print to
News Laundry.
News Laundry to the News Minute, etc., etc., etc. And then you have very large number, a much larger number in regional languages, and they are many of them are playing a really strong role of dissemination of information. Ultimately, what does media do? Forget about the viewpoints and the opinions and all, but just dissemination of information to tell people that, if you are being told that we are a Vishwa Guru, then please think of, what is the state of your potable water in your area?
True.
What is the maternal mortality rate? What is the infant mortality rate? What is happening actually in the country? What is the level of poverty? What is the difference between rich and poor? Is it growing, etc.? That dissemination of information is happening because of all these different online services which are available. Social media is one part of it. But there are, first of all, the online services which have become, many of them have become almost mainstream in a way because they are available all across the board. Then you have things like YouTube and all, where you have people, you have people on all sides of the spectrum in all these. So you have people who will be giving a very right-wing view, there will be people giving a very left-wing view, etc. But you also have some who have gained huge amount of traction and are respected for the information that they give. People like Dhruv Rathi, they have researchers working. They
Ravish Kumar.
Now Ravish Kumar would have been after NDTV was taken over and he resigned, and NDTV India was the largest Hindi channel at that time. But with his viewership was huge. But he would have been completely finished, but for the fact that this social media was available.
Yes.
And he immediately jumped onto it, and he's got he's got a huge viewership, not as big as it would be on television, of course, but still, big enough to make a difference.
Unfortunate part I have seen is those media houses praising UPA government, now praising the NDA government. The very same media houses, they had the same behavior when UPA government was there. some of them,
I don't think anybody was
as bad as it is.
Yeah, see, if you flash back to 2007, 8, 9, 10, and then all the way to especially
fear
from
factor was not
2009 to 2014, the media was actually arrayed against the government. In UPA 2, 2009 to 2014, there was a general perception that the courts, the media, etc., were arrayed against the government because the standard narrative at that time was that this is a completely corrupt government, that they are completely inefficient, nothing moves, nothing gets done. The president is Mohan, he doesn't speak a word. The prime minister is Mohan, he doesn't speak a word. The courts were on 2G and Colgate and iron ore scandals, and it was as though this government was that government was only there for corruption, and the media was playing that up. So it's not as though the media was with the government and promoting the government.
But I was mentioning some of the anchors.
Yeah. So, but that happens. That's like being chameleon.
And they are the prime time anchors now.
But afterwards, what has happened now? I think more so in the last 4 or 5 years, they went to a level where they were definitely more loyal than the king. Definitely, they would. If if you go to L.K. Advani's famous statement after the emergency, he said that you were asked to bend, you chose to crawl. Now here it is not even that you chose to crawl. Here you choose to crawl for the government and at the same time to play up for the public to hide anything and everything that the government has done wrong and to attack the opposition relentlessly. So now it's as though the mainstream media's only role is to question the opposition, not to question the government.
Absolutely. I would like to ask a very dangerous question. You mentioned that the media is being loyal to the government or king. Do you feel that the courts are also being loyal to the government?
So I think I would be less than candid or less than honest if I said that I'm happy with the way that the courts are functioning overall when it comes to especially those issues which are very, very important or very dear to the government, which are very dear to the government's heart. I think that our courts in general have, we have a tradition, and this perhaps is all over the world, that when you have very strong governments, the courts tend to take a step back. And when you have very weak governments, the court tends to take a step or two forward. So that you can understand, and that is something which would be fairly understandable. What disappoints me is that we have seen a period in the last 10 years or more, 10 to 12 years, where our courts are quite often functioning as though they are a voice for the administration, or as though they are an arm of the administration, and this is manifested in many ways, either by not taking up matters which are important, keeping them on the back burner, allowing them to die a natural death, or by voicing in open court without actually deciding matters, but voicing certain thoughts and certain ideas which the administrative machinery or the state might feel is very very important for them, and then which gives them a platform to develop things, or in terms of many laws which have been which I believe have been misused or abused, or have even been amended in manners which, on the face of it, makes them reek of unconstitutionality. But our courts have gone out of their way to either to uphold those laws or to push the day of reckoning and not take them up for hearing at all if they are likely to pass muster. So you have many things, but without getting into specifics, but take something like the FCRA, the Foreign Contribution Regulation Act. That was amended in 2009, amended again, and then amended in 2018, etc. During, I think it was when Justice Kehar was Chief Justice, or perhaps he was not, I think he was just around when he became Chief Justice, he suddenly took up this thing about how can there be so many NGOs in this country? And why are there, why are NGOs all over the place? And he actually initiated an investigation. Nothing came of it, but it became a huge cause célèbre. It was in all the newspapers, etc. And there was a sort of a relentless attack on NGOs. This was immediately followed by the government by cracking down on foreign funding of NGOs. Now, all kinds of NGOs which are doing really good work which the government ought to be doing or which the government is unable to do, is being done by NGOs. And what happens is that instead of lauding the NGOs or assisting them or at least leaving them free to do their work, they were relentlessly attacked. They were attacked first by the court. The court it is like the court giving an ishara and the government jumping on it. And so you had this situation of, lakhs of NGOs being de-recognized. Then, so first the deregistrations took place. That was in lakhs. Then there was this thing of FCRA cancellations, FCRA notices. So all across the board, and this has become a cycle. And it is like the courts and the government are playing in tandem. One takes one step, the other takes two steps. This one takes two steps, the other one takes... But it's really like they're absolutely acting in sync. It's like a lockstep march, which the courts are doing. And on many such issues, and ultimately, of course, they upheld all those amendments, some of which are absolutely deleterious amendments, all were upheld by a bench of a three-judge bench of the Supreme Court.
I just want to mention one aspect here. I think it is basically has got some connection with the social philosophy of the judges, because we have seen this collegium system. After this collegium system, most of the people, suppose if you want to be a High Court judge, and if you want to involve or raise your voice against certain injustice, then you will be treated as left, right, center, whatever may be. You will be portrayed as somebody, and since you have an opinion of your own, people may think that you are not the right candidate. The collegium may treat you as a person who has got some sort of a rebel or a person who is raising voice against something in the society. You have got certain politics. So that will be a disqualification for you, even for consideration. So people are really considering those people who have no opinion at all about any issues. Have you felt like that? Apolitical persons, basically. I'm not saying that you should be left, right, center, whatever, but those persons having no constitutional conviction or no ideology, even constitutional ideology.
The courts in general and the Supreme Court in particular have, when issue... See, in a large number of issues, the court might function perfectly well, etc. But the issues which are very dear to the heart of the government, the issues where the government is very deeply invested in those issues, there the court has acted like an administrative court. I think it has failed to really stand up for the values, for the constitutional values which are so essential and which only the Supreme Court and the high courts can, lay down and uphold for the country.
What is your take on live streaming? Because now the court proceedings are always live. So earlier it used to be something which was inside the courtroom, which had nothing to do with the world outside. So what is your take on it?
It's a difficult question because there's good and bad in live streaming. Live streaming really came about because of that Swapnil Tripathi judgment of the Supreme Court. The Supreme Court held that transparency, like sunlight is the best disinfectant. So if there's transparency, it will lead to courts. The feeling was that the courts would conduct themselves much better. The lawyers would conduct themselves better, knowing that they are being viewed outside, etc. And that overall it would lead to transparency, and therefore there would be less of finger pointing and so on and so forth, which is, I think, a very laudable objective. I think it's a very very laudable. It's something which you can't argue against it. it's definitely needed. The downside is 2 or 3 things. One is there are the young lawyers who might suffer because they don't manage to put up a very good show on a given day. All of us, even with more than 40 years of practice, there are days when, you just get hammered by the judges. And maybe your facts are weak, maybe your, the judges have a particular view on the matter, maybe your client's conduct was very bad in the lower court, or whatever it may be. There could be 100 reasons, but you can get hammered. Now, if somebody was to be judged on that, yes, it would be harmful for them. On the other hand, there are a lot of young lawyers who are able to advance their professional standing because of live streaming. Because there are some you'll find they are bold, they go there, they grab the mic, they argue, and they get known. So it's a sort of mixed bag. I would say that it's that part of it, of the effect that it has on people. There are some who are gaining from it. There are some who might get harmed by it. I don't know how you can balance that. The worst thing is that while transparency is very essential, but you had a situation where, for instance, when Mr. Kapil Sibal once in the Chief Justice's court made a grievance that his juniors and all were being heckled outside because they could be seen on the screen and they are being identified and are being heckled because there was an unpopular cause which he was representing.
So one other issue, because sometimes the judges will act as devil's advocate. So in that case, they may be asking certain questions. The general public may think that is a question by judge. He may be probing. So what happens, most of these people, what they do, just cut 1 or 2 seconds of the video and make it very sensational.
That is something the courts must lay down very, very strict protocols and make it very clear that if there's doctoring of videos, if there's unfair clipping of videos, if they are edited in a manner which gives a misleading thing, or if questions are reported by newspapers and by television channels as answers or as the judge's view. But they need to then lay down protocols and train people. I don't think you can set the clock back and go back to a situation where you just do away with live streaming. It's going to be very difficult.
So I think that's exactly what I was talking about. When I talk about live streaming, I mean the same thing that we talked about, having these clips and circulating these clips online. For example, if there's somebody who's argued, and now that argument has not been all that nice. Now, having to live stream it is okay. But now it is circulating across media, across the country.
And that person is getting a bad reputation.
Is getting a bad reputation, and that person might be a young lawyer or maybe an old lawyer, doesn't really matter. But now this person, despite having all the knowledge, despite being a really good lawyer, on the basis of that one clip, because social media has all the power these days.
Yes. I really don't have an answer, Can we go back to just doing away with live streaming and go back to where we were?
No, maybe not.
We also,
be circulated.
apart from live streaming, now today you have a situation where you have virtual access to courts. Now those two things go hand in hand. If you have virtual access, then people can still record what's happening.
Yes.
Even if you didn't have live streaming.
So maybe uploading that recording should not.
Live streaming basically is really good.
Yeah, but I think
making the system transparent.
I think the Supreme Court should probably take the lead and lay down protocols and make it clear and then disseminate these through high courts to all the media houses, etc., make it well known and make it clear that if there's violation of these protocols, it would be looked down upon. Number one, if there's a grave violation, then it might lead to repercussions, either contempt of court or criminal action or whatever.
This is also applicable to judges. Some of the judges who are really bullying, they are also somewhat moderate now these days.
Yeah, so
I'm not talking about any particular court, generally.
But what I'm saying basically is that I think because we have virtual hearings, and virtual hearings are, nobody will doubt that virtual hearings are a necessity now. I know lawyer friends of mine who had suspended their practice completely. Like they said, each time I had a child, my practice would be completely over. 2 years, 1.5 years, 2 years, I would be out of the scene. and I would have to come back and start off from scratch. And as it is, women lawyers have difficulty establishing themselves. And over and above that, if you have to take breaks for having a child, you would be relegated to this position where you would actually, 5 years of practice would be wiped out, and you again start off like a fresher. Then again, 5 years of practice are wiped out for your second child, and again you start off like a fresher. So what happened with virtual courts is that those same mothers or the next generation of mothers who were having children during 2021, 22, 23, etc., they could actually be back in court, maybe not the next day, but the next month. They could be breastfeeding their child at home and appearing in court. They could be, fully devoted as a parent, and yet maintain maybe not 100% practice, but a 60, 70, 80% practice, right? Which was impossible to think of. Which was impossible for litigation. It was impossible to think of before this. So, you have all that. Now you have people with disabilities. They are able to do virtual hearings, etc. So I think though there are ills to live streaming, I think we need to find solutions for the ills, but not
do away with it.
Throw the baby out with the bathwater.
So because you're one of the most sought after seniors, as I've heard from many people, and most of your juniors have great things to say about you, and even the ones who are not your juniors have wonderful things to say about you. What do you think is a senior's role in a junior's life?
Well, I think the most crucial element that seniors must get their juniors to imbibe or must pass on to their juniors is a value system. I think it's very crucial. We are in a profession which, at least at the upper levels of the profession, has become one of the very, very highly paid, perhaps the most highly paid profession in India. Like I said, at the upper levels, among all the top performing lawyers and all, I doubt very much if any doctor or architect or engineer or other professional would be earning. But what should not get obscured in all that, in the fact that there is a lot of income to be made, a lot of earnings to be made, what should not get obscured is to have proper grounding in values, proper human values, to have proper values of a moral and ethical compass to guide one's life. I think that is something which is very important. Which can and only will come from the seniors, because if seniors don't make that extra effort to share with their juniors what sort of value systems are needed, what sort of how they should conduct themselves in the legal world as well as in the world in general. It's very easy for people to get carried away by the pomp and show and the sort of, to put it very crudely, the lure of filthy lucre, which is which would completely which can derail people's way of thinking and all that. And that I believe that if you run your practice ethically and well, if you work hard, the sky is the limit in our profession. But there's absolutely no need, there's absolutely no justification, there's absolutely no necessity to cut corners. There's no need to take shortcuts. There's no need to game the system or to play the system or anything. There's just no need, because you can do very well and you can sleep well at night and yet do very well, professionally, maintaining values where you can hold your head high in society. And I think that, to my mind, that is the most crucial thing. If I can, if I can share that with my juniors, and if they maintain a solid head on their shoulders, I think that is the greatest thing one can do.
So something which I just to have an opinion about. the so-called bail jurisprudence, because we all know that and we all talk about it, that bail is a matter of right and jail is an exception. But that is not happening. That is only happening in seminars and speeches. But in real term, it is not happening. The bail hearings are going on for 3 months, 4 months. It's a matter of bail or anticipatory bail. So why this? What is your take on this?
So there are two things. One is normal bails with normal bails in the case of normal crimes. Even there, like you said, bail hearings can get prolonged, can take months, sometimes 2 months, 3 months, 4 months to get heard. And then the general tendency has been, the Supreme Court has spoken about this, that the tendency has been for trial courts to deny bail as a matter of course. And more often than not for high courts also to deny bails. And so the Supreme Court ultimately is called upon to grant bail as the first court granting bail. And the Supreme Court itself has lamented this. Many judges have said this in open court. They've even written it in judgments. But at the same time, what does happen is that sometimes mixed messages are sent down. Sometimes when courts are quick to grant bail, they get criticized. Trial courts which are quick to grant bail get criticized by a high court or criticized by the Supreme Court. So sometimes you have, Supreme Court judges saying that this particular judge has given multiple bail orders with similar reasons. Now there are only so many reasons you can give. If you're going to be a diligent judge and you're going to grant bail, you're going to be generally giving bail wherever it's possible to give bail and denying it only where it's needed to be denied. Then your reasons are going to read pretty similar. So if you're in a criminal, in a criminal assignment in a court, in a very large court like Allahabad High Court or Bombay High Court or somewhere where there's and your assignment is bails and you're getting hundreds and hundreds of bail applications, your orders, wherever you grant bail, will tend to read, because what are you looking at? You're looking at whether the person is a threat to society, whether the person is, whether there's a
flight risk,
whether the person is, what should be the terms and conditions imposed on the person. They will tend to read similarly. So if they get criticized by the Supreme Court or by the High Court for that, then judges the trial court again go on the back foot. Then they start denying as a matter of course. So we have too much of this back and forth, going on in normal bail. Special laws like the UAPA, the Unlawful Activities Prevention Act, the PMLA, the Prevention of Money Laundering Act. The police authorities do is they make a narrative. They are not now investigating. They're picking up people on suspicion, but based on a narrative. And the charge sheets are filed of 5,000, 6,000, 7,000 pages, 12,000 pages charge sheets, which are just one long narrative. There's nothing really in those which is really matters of substance to actually nail the person or to pin the person down. The narrative is made, and that narrative becomes so difficult to overcome at the bail stage that the trial courts and the high courts, almost as a matter of course, deny bail. Then it comes to the Supreme Court. Now, the Supreme Court ultimately, faced with this situation, realized that people are languishing behind bars for 5 years, 6 years, 7 years, with no possibility of a trial getting completed in the next 5 years or 10 years. Because their long narratives are woven with 380 witnesses, 560 witnesses, 1,000 witnesses, and 9 lakh pages of documents, and so on and so forth. The Supreme Court, when it was faced with this situation, that long incarcerations were there with no hope of a person getting out, and people were behind bars for 5 years, 6 years, 7 years. Then in certain earlier cases, the Supreme Court had taken the view that if there is long incarceration, that itself violates Article 21. That thought that long incarceration violates Article 21, and regardless of bail conditions, Article 21 will then trump the deleterious bail conditions. That thought lastly was cemented by a 3-judge bench in the case of K.A. Najib in 2021. Right? So, but K.A. Najib was not the first judgment to say that. This thought that Article 21 will kick in when there is a very prolonged incarceration without hope of trial had already been evolved by the Supreme Court earlier. But K.A. Najib was a 3-judge bench which said that regardless of the seriousness of the charges, regardless of the seriousness of the offense, if a person is behind bars for 5 or 6 years and there is no hope of an early trial getting concluded, or it is apparent that the trial it's impossible to complete the trial, then that itself is a ground for grant of bail without looking at anything further. This was laid down by a 3-judge bench in Najib. This was then followed by a number of judgments, not 1, not 2, not 3, not 4, by about 20 judgments. It has been followed. The Najib principle has been followed again and again and again under the PMLA, under the UAPA, under numerous laws, under all the laws where these triple tests are laid down. Now, there were only 2 judgments where a contrary view was taken. The first was Gurvinder Singh. And in Gurvinder Singh, they distinguished Najib for the first time in Gurvinder. That again has been followed by, in the case of Gulfisha Fatima, where the Supreme Court, in my submission, ignored the large number of judgments which said the seriousness of the charge is irrelevant. If you are not able to complete a trial expeditiously, then Article 21 gets violated and the seriousness of the charge or the wording of the law is completely irrelevant. The 3-judge bench was then followed by 2-judge benches. At least 2 of those 2-judge benches, they said the prosecution should not even be allowed to argue against bail if they are not able to ensure an expeditious trial. So Justice Pardiwala has categorically said that it will not lie in the mouth of the prosecution to argue. We will not allow the prosecution to argue against bail if they cannot ensure a speedy trial. Because speedy trial is the essence of Article 21. Now, in Gulfisha Fatima, the court again harked back to the Gurvinder Singh and on the same basis held, separated out of 7 odd persons who were facing similar identical charges. 2, they said, have played, according to the court, a greater role, and they on that basis they said because they have played a greater role, they can't be let out at this stage, and they should stay for 1 more year. Now, what is the logic of 1 more year is not explained. What is the basis on where the Supreme Court says that Article 21 will be met after Article 21 will be violated after 1 year, but is not being violated today, even though charges are not framed, even though the possibility of framing charges and completing the trial is not there for the next 10 years probably. So it is these judgments were a departure. So lastly, what happened was that another bench of 2 learned judges in the case of
Justice Bhuyan.
Justice Her Ladyship Justice Nagaratna and His Lordship Justice Bhuyan, they ruled in one matter. They analyzed these judgments and they said that these judgments are outliers. Nobody has ever said that the law changes. All that they have said is that Article 21 guarantees a speedy trial. And if the state is not in a position to provide a speedy trial, then the state cannot oppose bail. Absolutely. Now, that is absolutely logical, that is absolutely unassailable, that is absolutely, something which I think is unexceptionable. You can't take exception to this logic, that either the state ensures a speedy trial or the person must be granted bail. That's all. That's all there is to it. There's nothing, there's no... it's not rocket science. It's not something which requires Einstein to come down from the heavens and explain this law to us. You know, we all must understand what is Article 21. It's one of the most cherished fundamental rights. It's not given to us by the Constitution. It's a basic right. It's an inherent human right. It was there from 5,000 years. It was there from 5 million years ago. Yes. Article 21 only guarantees it.
So just imagine the plight of those law school teachers. They will have to teach this. Look.
So I just feel strongly about it. I feel that we must we must apply our knowledge and apply our practical sense. Now, let me say this loud and clear, that I don't believe that any judge of the Supreme Court of India does not know, hand on heart, does not know what is the reality of these incarcerations in Bhima Koregaon, in the Delhi riots cases. I do not believe that any judge believes in their heart that there is even an iota of truth in the charges.
True.
You can put a gloss on things. You can say that, very serious allegations are made. They are allegations. They are only allegations, and every judge knows that those allegations are hollow. They will crash to the ground. They will crash and burn. Justice Sanjeev Khanna, when he was in court number 2, he said it in open court. He said, Mr. Solicitor General, Mr. Raju was arguing a matter. He said, 2 questions in cross-examination and your entire liquor scandal case will go. Right? What happened? The trial court has given a 589-page judgment saying that there is not even an iota of a case for framing of charges. Justice Sanjeev Khanna said this 2 years ago.
True.
2 questions in cross-examination, Mr. Solicitor General, your case will go. And they can't frame charges. Big liquor scandal. People were Chief Minister, Deputy Chief Minister, Home Minister of Delhi government, Ms. K. Kavita from Telangana, 23 accused, all top politicians, businessmen, etc., all discharged.
True.
So, when we talk about bail, we must know this. We know these are all hollow cases. These are all narrative-based cases. There's nothing in them. They will all crash when they're tested.
So thank you so much for being so straightforward and being so open about things. You've explained things in a manner that I think everybody should be able to get what you're trying to convey. It has been an amazing conversation, and thank you so much for joining us, sir. And there's a ritual that I personally follow at the end of the episode. What would your message be to lawyers, especially first-generation lawyers, because you are one? I think so is sir. So what would your message be, just to navigate and just to cut through life as a lawyer?
I think the main thing is to believe in your clients, work hard, and just don't think of hurdles and handicaps and all that. Take up every case as though it's as though everything your client really, the client's life depends on you, and go for it.
So because you're an ex-journalist as well, I would want a message for journalists as well, for the media particularly.
What can one say to the media? I can only repeat Mr. L.K. Advani's prophetic words after the emergency when he said, "You were asked to bend, you chose to crawl." Don't do it.
We hope you liked this episode. There's so much to learn. There's so much that has been talked about. We will be back with another episode, another personality, another legal mind who also has something else to talk about. Please stay connected with us. Like, follow, and share the videos, and also show your love in the comments. Thank you.